Lecture number 182, Contracts 1, General Principles, Section 1 to 75 of the Indian Contract Act is the topic for discussion. In this lecture, I will try to cover to the best of my ability and knowledge whole subject of Indian Contract Act from section 1 to 75. In this lecture, I will enlighten you on introduction of the Indian Contract Act, meaning, definition and elements of contract. Elements are requisites are ingredients or conditions of contract. Each and every element will be studied as independent chapter in the subsequent chapters. For example, contract first element, offer and acceptance will be studied as next chapter, that is second chapter. Next element, lawful consideration, section 2D will be explained in next chapter. Next element, free consent in next chapter. Next element, capacity of parties in the subsequent chapter. Legality of object or lawful object will be next chapter. After all the ingredients are over, we have to discuss about different kinds of contract. There are 5 kinds of contracts. Thereafter, when once a contract is entered into, will be completed or discharged. If it is discharged in a successful way, positive way, we call it as performance. If it is not completed, if it is the contractual obligations are not fulfilled by either of the parties or both the parties, then it is called breach of contract. We have to discuss some items in performance of contract and breach of contract, namely appropriation of payments, joint liability, doctrine of frustration, the principle of novation. Such topics we will take up. After discharge is over, next topic will be the remedies. The one who if one party commits breach, if one party fails to perform the contract, the other party will file a case against the farmer for some relief. There are different kinds of reliefs called as remedies. And this next chapter we will discuss in brief about remedies. What are the various remedies? Lastly, there are some instances in which contractual obligations are imposed in the members of the society. Though generally contractual obligation is created out of an agreement, but without entering into any agreement between 2 or more parties, by virtue of the principles of natural justice, equity, the contractual obligation will be created. Such type of contracts are called quasi contracts. If the quasi contracts is breached, if the quasi contractual obligation is breached, what the other party, aggrieved party, can bring an action. There are 5 kinds of quasi contracts under section 68 to 72. These are the topics I will cover: meaning, definition and elements of contract, each and every element in the subsequent chapter, performance or discharge of contract, remedies of the contract, and finally quasi contract and the different kinds of quasi contracts is the whole syllabus of this subject. Before going to start this subject, dear friends, let me give 1/2 minute to pray God, pay homage to my reverend parents, late Rega Parao and late Srimati Kantaratnam, and my beloved wife, Mrs. Balivada Rega Tirumala Gauri, my co-academic associate. Let me express my heartfelt gratitude to my godfathers and publishers. Let me express my gratitude to the publishers of textbooks, uh, publishers of articles and research papers in internet, and finally I deem it as a duty, honor to express my deep sense of indebtedness to my student friends who are mainly instrumental for what I am now. Today, introduction. By the time we get up from the bed and till we go to bed in the night, every individual, every human being in the society is associated with different personnel to meet his day-to-day requirements. For instance, immediately he has to clean his mouth, he requires brush, then breakfast. To reside, he requires some shelter, either as a tenant or as a purchaser of the flat. Like that, for whatsoever activity we take up in regular course of life, will be associating with one individual or other individuals, because for successful survival of human life, requirement of goods, commodities and services are very essential. Good services in the sense, we require water supply services, we require electricity services, we require gas agency services and many other services. So for our regular course of life, we will be associating with variety of people. With the type of association is results in a contract agreement between two parties. If that agreement is legally recognized, legally enforceable, that agreement will become a contract. So this is, if we enlist all the human activities as agreements or contract in a particular legislation or an act, the number of sections will be in thousands. That is why, depending upon the nature of transaction, depending upon the nature of activity, some activities are enlisted as contracts in Indian Contract Act, some have enlisted in Sale of Goods Act, some have enlisted in Transfer of Property Act, and so on. So what is this Contract Act? When it was passed and came into existence, what are the topics it contains, we will have to discuss. In prior to our independence and our constitution in 1950, we the people of India, that is the territory of India, was governed or ruled by the Britishers for 3.5 centuries, that is from 1600 AD to 1950. During that period, so many law commissions were established. During the period of Third Law Commission, 19 acts were passed. This Contract Act is one among those 19 acts. The other acts are Indian Penal Code 1860, Criminal Procedure Code 1861. Subsequently, it was recodified from time to time, 1898, and then recently, in latest by 1973 Criminal Procedure Code. Civil Procedure Code 1908, Transfer of Property Act 1882, Easements Act 1882, and so on. So out of the 19 acts, this Indian Contract Act 1872 was one. This Indian Evidence Act also was passed in year 1872 during the period of Third Law Commission. So the law relating to contracts is regulated or governed by the Indian Contract Act. This Contract Act basically categorized under two heads. Part 1 containing chapter 1 to 6. Part 1 containing chapter 1 to 6, containing sections 1 to 75, lay down various provisions relating to principles. Chapter 7 to 11 containing sections 76 to 266, lay down various provisions relating to specific contracts. Dear friends, this bifurcation as part 1 and part 2, that is principles and specific, you can find in some legislations like Indian Penal Code, Transfer of Property Act, and some other legislations. As a student of law, you are expected to know what do we mean by principles and what do we mean by specific. Principles are common, specific are different kinds of contracts. As a common example, I told you so many times. Now let me tell once again. That is, for example, human being. Certain organs, external, internal organs are common to every human being. Treat them as principles. But these organs differ from male to female and misgender. So there are some special features to male, some other special features to female, and some other special feature to misgender. So this is called specifically, human being is specifically categorized as male, female, misgender, like that. Similarly, Hindu, Muslim, Christian, Jews, like that. Similarly, American, Australian, Pakistani, Indian, and like that. So this is called. So whatever may be the human being in any country, the basic ingredients of human body, basic organs of human body are common, like heart, brain, kidneys, lungs, eyes, nose. These are common to every individual in entire universe. That is why, apart from the basic ingredient, some other special features will be there. Like that, Indian Contract Act Part 1 containing chapter 1 to 6 containing 75 sections deal with principles. The second part deal with specific contract, which we are going to take up in contracts 2. It will be in syllabus for your second chapter. So let us give you a brief idea about chapter 1 to 7, chapter 1 to 6, the 1 to 6 containing section 1 to 7 lay down deal with principles of the contract. That is the subject. I will give the summary of the same. But second part, that is chapter 7 to 11. These chapters containing section 76 to 266 deal with specific contract. Section 7, which dealt with transfer of movable property from one person to another person, that is goods and services. Goods and services were dealt in Contract Act. In this area, litigation was increasing had been increasing from time to time. This chapter 7 containing section 76 to 123 was deleted by passing of Sale of Goods Act in the year 1930. No, earlier all transactions of movable property, that is goods and commodities, from one living person to another living person were earlier governed by Contract Act chapter 7, 76 to 123. Today this area was deleted in Contract Act and replaced by the Sale of Goods Act 1930. So these transactions, litigation relating to transfer of movable property is studied by this Sale of Goods Act. And this chapter 8 containing 124 to 147 lays down various provisions relating to contract of indemnity and guarantee. So the contract is entered into by two or more persons. The matter of two, generally in all contracts there will be two parties or two persons, whereas in contract of guarantee there will be third party called guarantor or a surety. Traitor, creditor, and surety or guarantor. Third person will come into picture. That is chapter 8. Chapter 9, containing section 148 to 181, lay down various principles relating to bailment and pledge. Bailment refers to transfer of property for some specific purpose. Pledge refers to transfer of, if movable property is pledged for a loan, it is pledge. If immovable property is given to bank for loan, it is called mortgage. Suppose you give loan, you tender loan and take money from bank, that is gold is movable property, it is called pledge. If you give your house or land as security and take money, it is called immovable, it is called mortgage. That is 48 to 181 lay down various principles relating to contract of bailment and pledge. You study in second semester, then 10th chapter, 182 to 238 lay down various provisions relating to contract of agency. If you engage somebody to act on your behalf, whatever wrong is committed by him, you have to hold responsibility. That is what is called contract of agency. And the last chapter, chapter 11, containing section 239 to 266. The last chapter containing 239 to 266 was deleted by section 73, schedule 2 of the Indian Partnership Act. Partnership Act also is a kind of agreement. I will tell you in course of time in second semester. This is the content of this. This Indian Contract Act originally contained 266 section. In addition to section 19A and 178A, two other sections were there in subsequent chapters. 19A relates to undue influence. This relates to a pledge of voidable contract like this. This Contract Act was updated in December 2018. This is the something in brief about this subject. Now I shall proceed to contract meaning, definition, elements or requisites or conscience, whatever it may be, elements, ingredients, requisites, conscience, qualification, conditions, all are same. So all are same. So when this is an opportunity in this subject, when I speak, when I explain you meaning, definition and element, most of the chapter summary will be over. Then I will tell you different kinds of contract, 5 kinds, and then I tell you breach of performance of contract and breach of contract in next chapter. And next I will teach you this remedies. Finally, quasi contract. I'll try my level best to complete all these aspects in this first lecture of 1 hour 6 minutes 50 seconds. And please extend your patient hearing. Now, contract meaning. Contract meaning. In first chapter, you study the meaning of contract, definition of contract, and elements of contract, and finally different kinds of contract. Contract is an agreement entered into between two or more parties subject to certain terms and conditions for a lawful consideration. Suppose when two persons come together, agree to a particular thing, it is called agreement. Suppose A wants to sell his house, B wants to purchase his house, if both agree, then A wants to sell, B wants to purchase, both agree for that. That is called agreement. Both three consented to do a particular act. So sale of house is legal and lawful, and so it is for lawful consideration. That if it may be oral or writing, that agreement may be oral or writing. If oral means you have to establish evidence. Agreement means that instrument itself will be the written instrument. So a contract is an agreement entered into between two or more parties subject to certain terms and conditions for lawful consideration. Two parties means two sides, one person, and other side also one person. Sometimes one side one or more, other side one or more. So that is. So basically there are two parties. There are certain exceptional cases, there will be more than two parties. within contract of guarantee, there will be two parties. In a trust, trust owner, trustee, and beneficiary, three parties will be there. In certain exceptional cases, third party also will be there. That person is called stranger to consideration, can also becomes party, and he will be entitled to file a case if the contract is breached. Now, the section 2H of Indian Contract Act tells you an agreement enforceable by law is a contract. An agreement enforceable by law is a contract. Some agreements are enforceable, some agreements are not enforceable. Suppose both parties agree. One party proposes and other party accepts. One party proposes. The person, if A wants to sell his house, A is proposing to sell his house. A is called proposer or promisor. He is also called offerer. That means A is offering his house to sell to B. If when this offer is extended to B, B is called offeree. When this promise is extended to B, B is called promisee and promisee. So before acceptance, he is called promisee or offeree. If B agrees to purchase the house, that is called acceptance. That when once it is accepted, the promisee or offeree will become the acceptor. So this offer and acceptance must be wholehearted. Wholehearted means A may like to be, A may agree to marry B, B may agree to marry A, but out of some force, elders' pressure, or a threat of suicide, that is coercion, and any reason, it is then that consent is not free. It should be wholehearted. Secondly, both the parties must be competent to contract. Suppose if a child of 5 years goes to jewelry shop and purchase a necklace worth 1 lakh and it gives money 1 lakh, that jewelry owner will not accept 1 lakh and give her necklace. So who are you? Who is your father? Who is your mother? These things you do. If he directly takes money and gives jewelry, if anything goes wrong, the police will investigate and arrest him. So when once a contract is to be entered into, both the parties must be competent. So that is why when two or more competent parties, within the meaning of section 11 and 12 of Indian Contract Act, freely consented to, within the meaning of section 14, not influenced by flaws in consent under section 15 to 20 of the Indian Contract Act, an agreement not declared void under section 23, subject to not being subjected by the agreements opposed to public policy under section 26 to 32 of Indian Contract Act. For a lawful consideration under section 2D, that agreement is called valid contract under section 10 of the Indian Contract Act. When two competent parties freely consented to enter into an agreement not declared void for a lawful consideration, that agreement is a valid agreement and is enforceable under section 10 of the Indian Contract Act. Section 10 contains some conscience. That is a competent party, section 11 and 12, freely consented, section 2D, not influenced by 15 to 22, and not declared void, section 23, not affected by contracts of opposite to public policies under section 26 to 30, 26, 31, 32 contingent contract that are enforceable. And lastly, lawful consideration under section 2D. This is what is called meaning. So, to constitute an agreement, offer and acceptance is enough, but for its enforceability, when offer plus acceptance simply becomes agreement, if the agreement is enforceable, then only, if an agreement to be enforceable, it must contain legal consequences, then only the agreement containing legal consequences can be enforceable. That agreement becomes, if a valid agreement which can be enforceable and can be implemented before court of law by filing a case, that agreement becomes a contract. So this is the position. Suppose husband promises wife to maintenance. Maintenance is if husband doesn't maintain wife, she can file a case against husband for maintenance, it is enforceable. Suppose husband offers wife for a diamond necklace, if he doesn't purchase, wife cannot file a case against husband for enforceability. That is not enforceable. So these are the things. Legal agreements are enforceable, moral agreements are not enforceable. This is the position. So what are the meaning is over, definition is over, elements. What are the various elements of what are elements, requisites, ingredients, conditions, all are same. Element number 1, offer and acceptance. To constitute a contract, there must be two parties. One is the offerer, other is the acceptor. Offer and acceptance. Section 2A defines offer, Section 2B defines acceptance. One who offers is called offerer, one who accepts is called acceptor. One who accepts is called acceptor. What is offer? What is accepted? Suppose I want to offer my house, sell my house. The seller is offerer. Yes, I am ready to purchase. Purchaser is acceptor. Suppose purchaser first asks seller, I want to purchase your house. Do you like to sell it? Then purchaser will be offerer. And yes, I am ready to sell. If seller tells, seller becomes. From whom this proposal rises, that is called, that man is called offerer, that party is called offerer. Other person who acknowledges the proposal or offer is called acceptor. Acceptor. So this is meaning. So the first condition is what is offer, what is acceptance, what are the different kinds of elements of offer, what is the revocation, what is the communication of offer is one topic. General offer, specific offer. General offer, specific offer is one topic. General offer means if a house is there, board is there, to let board, this house is for sale. Anybody on the road can come and offer to purchase. Similarly, if it is given in advertisement, it is a general offer. So, specific offer means A offers his house to for sale to B or group of person, that is specific. If offer is made to one person or group of person, that offer is called specific offer. If the offer is made to the people, a general public as a whole, that is called general offer. This is general offer with reference to Carlyle versus Carbolic Smoke Ball Company. I will explain in detail in the respective chapter. Next, communication offer. When offer and acceptance should be there, one person's offer should be made known to the other person. Once inclination must be brought to the notice of other person, then only it must be communicated. Otherwise, the contract cannot be constructed. Suppose a boy is there, a girl is there. The minds of girl, if she wants to marry him. In boy also, in his mind, he wants to marry her. Both are having inclination to marry each other, but they do not speak. Ultimately, the girl got engagement, then the boy suffers. So actually, I wanted to propose you for marriage. Now you are too late. So you did not reveal what is there in your mind. I too did not reveal what is there in my mind. So when once this inclination remain undisclosed, not communicated, in the absence of communication of offer, there can be no agreement followed by no contract. What is communication offer and all these things I will tell. Similarly, next one is cross offers. Cross offers. What do you mean by cross offer? A from Calcutta writes a letter to B in Bombay, and B in Calcutta, B in Bombay writes a letter to A in Calcutta. A wants to sell his B's house, B wants to A wants to purchase B's house, B wants to sell his A's house. So both offers are there, they are crossed. When after receiving letter, they cannot say that both are only offers, there is no any acceptance. After receiving letter from B, A must communicate to B. So after receiving letter, that is the offer, then he should accept. These things must there. We cannot say that when once both are willing to purchase and sell, the proposals are made, they are called cross offer. This topic I will explain in detail in the respective chapter. Revocation of offer. Revocation of offer means Today we want to purchase one house. After some time we want to cancel the program. We don't want that house. We will tell. Suppose we propose when this offer can be revoked, when this acceptance can be revoked, will be can be withdrawn. We will study there. This is regarding offer and acceptance. Similarly, correspondingly, acceptance will be there. Acceptance is studied under Section 2B of the Indian Contract Act. Next essential element is consideration 2D. When the promisor and the promisee or any other person does or abstains from doing, has done or abstained from doing, does or abstains from doing, promises to do or promises to abstain from doing, the act or abstinence is called consideration. If one person, when a contract, consideration is price of the contract. Consideration is very essential for formation of the contract. So, ex nudo pacto non aritor actio, out of a nude pact no cause of action arises. So, A sells his house to B pays money to A. A sells his house to B for 50 lakhs, B pays 50 lakhs to A. 50 lakhs becomes a consideration to A, house becomes consideration to B. Similarly, A wants to marry B. So, B becomes consideration to A becomes consideration to B, because there cannot be any price, dowry or kanya sulka. Bride price or bridegroom price cannot be valid and enforceable. So, this is a consideration. Consideration for every contract, consideration must be there. It may be more or less immaterial. Consideration need not be adequate. Need not be 1 crore house can be given to 1 lakh or even 1,000, still that contract is valid. So similarly, consideration need not be adequate. It may be past or present or future. Past, present and future are valid in India. In England, past consideration is no consideration. This detail I will explain in the consideration chapter in detail. In that consideration chapter, there will be one quotation. A contract without consideration is there. That quotation, without consideration also contract is valid. Section 25, clause 1, clause 2, clause 3. These 3 items are there. Namely, love and affection, payment made by past services rendered, time bounded. These aspects I will study, I will explain in that consideration chapter. So this is privity of contract or stranger to contract and stranger to consideration. Stranger to contract, A is seller, B is buyer. If A doesn't sell B alone can file a case against A. But B's brother or sister or wife becomes stranger to contract, he cannot sue. Only parties to contract can sue one another. A breaches, promisor breaches, offeror breaches, acceptor can file a case. Offeror breaches, acceptor breaches, offeror can file a case. These two alone are connected to contract. Anybody other than these two cannot come into picture and file a case. So suppose I have given given a contract to contractor for construct a house paying 50 lakh, but the contractor is not doing work. I can file a case against the contractor for good performance and specific performance. My wife or brother, son or daughter cannot file a case because they are stranger to contract. The contract connects the tie between me and that contractor. We both are the parties. However, there are certain circumstances in which the beneficiary will be there. That beneficiary also can bring an action that he is called stranger to contract. Stranger to contract in the sense, in trust beneficiary settler, what happens is, and the principles of government college, government gives money, scholarship to students. The contract is created between government and me. I am accountable to government. Suppose if I misuse the funds without giving scholarship to students, I eat it, it amounts to breach of trust, tort and crime, civil and criminal liability. So the beneficiaries, my students also can bring an action against me. That is, they are stranger to consideration. A contract a stranger to contract cannot sue. A stranger to consideration can sue. This is the privity of contract. This topic I will explain in detail with relevant case law. This is another thing. The next item is contract. Next element is capacity to contract, competence of contract. Section 11 and 12 of the Indian Contract Act lays down various principles relating to capacity or competence of the contract. Section 11 speaks about minority, Section 12 about unsoundness. Suppose a person who has completed the age of 18 years, 18 years is major. If his property, to look after his personal property, personal security, body security and property security, if a guardian is appointed, then the minority extends to 21 years. Up till completing 21 years, he will be the minor according to Indian Minority and Wards Act 1875. Because so when father and mother are natural guardian, if suppose the ancestral property comes to him and the father are no way connected, that grandfather has written a will about some property, it should go directly to the grandson, then the father and mother doesn't have any right, but then they will be the natural guardian. Sometimes if the father or mother, they become deaf, dumb, unsound or converted persons, so sannyasis, whatever it may be, if the mother and father are declared incompetent to enter into contract, some guardian will be there. Sometimes the court will appoint the guardian. This is a person who wants to enter into a contract must be a minor, must be a major, must not be a minor. A contract entered into with minor is void ab initio. From the very beginning it is invalid. It was laid down by the Privy Council in Mohri Bibi vs. Dharmdas Ghosh. All the details I will take up in that particular chapter. Second, section 12 speaks about unsoundness of damage, unsoundness of mind. So a mental man, pagal man, won't be able to enter into contract. Suppose before going to, if anybody got intoxicated, an intoxicated person, if he having consumed alcoholic drink or having consumed drug or any other thing, when once a normal man becomes out of control, his brain will not function. What he is doing, he won't be able to teach you. In insanity chapter, the IPC I explained in detail. This topic, if you want, you can refer this. So the unsound mind cannot, because for example, you go by the time of entering into bar, they speak very decently. 9 o'clock they enter, by 12 o'clock they started drinking. They speak some nonsense. You can witness that in any bar. So that is why when once excessive consumption of alcoholic drinks would result in imbalance of the mind, imbalance of the brain, and he won't be able to speak properly, he won't be able to distinguish between right and wrong. Such person is declared incompetent to enter into contract. That is this thing. Next topic is, next chapter is, this is one chapter, one ingredient. This will be taught elaborately in this. So other disqualification, insolvent is there, convict is there, for alien enemy is there, these also are there. Insolvent means whose businessman, whose liabilities are more over the asset, he won't be able to run the business. He will file petition in district court for adjudging as insolvent. Then the court will adjudge him as an insolvent and will take over all the properties and will appoint some official called official receiver. That official receiver will take over all the properties and distribute these limited assets against unlimited creditors as per the priority. Then that person is called insolvent. Though he is the owner of the properties are handed over to the government through the official receiver. He is not competent to contract. He cannot sell his house properties. That is why he is incompetent. Convict. A person who is convicted, he is absconded. He may be called for the court. He is absconding, and the court will then, after last resort, his property will be seized. So then, though he is the owner of the property, but out of conviction, when once his property are seized by the government, he won't be able to enter into contract. That is convict. So that is foreign alliance. Suppose the war is going on between Russia and Ukraine, and prior to war, the individuals traded in Russia and traded in Ukraine can enter into contract for trade, supply of goods, commodities, whatsoever. When once broke out between these two countries, the Ukraine citizen will become enemy to Russian citizen. Russian citizen will become enemy to those persons. Then these two enemies cannot enter into a contract. So these are these about section 11 of the Indian Contract Act. Details I will take up with this particular chapter. Next important thing is legality of object or lawful object. When parties enter into a contract, that contract must be legally valid, lawfully allowed. In some countries, prostitution is not legalized. In some countries, prostitution is legalized. In India, prostitution is not legalized. If any two parties enter into a prostitution agreement, that contract is immediately illegal. Why? It is opposed to public policy. So, for printing of fake currency, it is illegal. It is prohibited. Subsidiary, there are so many illegal contracts are there. If two persons enter into contract, that contract is illegal. So when two parties want to enter into contract, that contract must be legally acknowledged, legally valid. If it is invalid according to the law, that contract cannot be entered into. If that contract is why because they are opposed to public policy, that type of contracts are there under section 26, 27, 28, 29 and 30. 31 and 32 deal with contingent contracts, they are valid. These aspects you will study in the next chapter. 26 relating to contracts relating to marriage. Section 27 relating to agreement in restraint of trade. Section 29 related to uncertain contents of the contract is uncertain. 30 speaks about wagering contract. Agreement in restraint of marriage, section 26 speaks about, suppose agreement in restraint, I will, a man promises a girl, no, I want to marry you. In case I leave you after some time, you should not file a case against me for restitution of conjugal rights or maintenance. So because she is a poor woman, nobody is there to marry her. If you are out of hungry stomach, she agrees. Okay, sir, you may marry me. You may treat me as your wife. I am not hopeful that I will get married in my life because of my poverty. She agrees. After some time, after spending matrimonial life for some 2-3 years, he will leave her. Then she may file a case for restitution of conjugal right. She may file for maintenance. That man cannot say at the time of marriage, I told you in so many words that when once I leave you, you should not seek any relief. So code of law is what that man cannot say. She has got every right. Any agreement against matrimonial relief is so agreement in restraint of marriage is void. Third contracts are bad. Next one is in agreement in restraint of legal proceeding. There are so many acts. They speak something. Some agreements are made outside the inconsistent to the provisions of the act. For example, Copyright Act is there. Copyright Act contains so many benefits and positive provisions to the other. But the publisher may take an agreement outside without inconsistent to the Copyright Act for his benefit. That author inevitably and invariably, if he doesn't agree, he won't get the opportunity to write the book. Then the agreement is finalized. When once author wants to file a case, publisher cannot say that he agreed for all these things, so that the agreement is void. The court will dismiss that the agreement entered into between the parties and will protect. So these are the things. Whatever is there in law, any agreement must be made in consonance with the provisions of law. Nothing should be inconsistent. This is what is called legality of object. Similar 27 is agreement in restraint of 28 agreement in restraint of legal power. 27 is agreement in restraint of trade. Agreement in restraint of trade means I am running a business, opposite one shop is there, I request the opposite shop man to close the shop and go, I will give you some 5 lakhs. Then according to my request, that man closed the shop and he asked me 5 lakhs and I did not give, he files a case. So any agreement, Article 21, Article 19(1)(g) confers fundamental rights on every individual to take up any profession or business in entire India. That is that. So this is first thing. Another thing is this agreement restraint of state. 29 speak about uncertain contents. Suppose when a contract is entered into, the terms of contract must be certain, clear, otherwise the contract is not valid. So letter to market, which place, like that. there is a proverb in this. Suppose when you want to have a order for oil trader who is dealing with coconut oil, ginger oil, groundnut oil, sunflower oil, I think. When you ask place an order for 20 tins of oil, you should specifically mention whether it is a coconut oil or ginger oil or groundnut oil. Simply you send 20 tins, it is not clear, that contract is invalid. Suppose A always orders coconut oil only, this need not be mentioned, it is implied. It is implied, then it is valid. So the terms of offer must be clear. The terms of offer must be clear. This topic we will explain in detail in bumper falcon cases there. Harry versus Passy and all these things are there. This is another topic. So these are next section 13 speak about wagering contract. Wagering means betting contracts. Suppose betting contract means in cricket match betting, that is wager. So in election time, one political party will come to power and other political party will come to power. In some consciences, that candidate will come to power or this candidate. That type of contracts are called betting contracts. Those betting contracts are wide. They are opposite to public policy. When once they are done, the police will raid and seize those activities. So this is the legality object in this over. These are the various ingredients or content that constitute a valid contract. This is the position. So contract meaning, definition, elements are over. These are start separately in independent chapter. I will tell you. Then in contract there are different kinds of contracts. There are 5 kinds of contract. One is valid contract. Second one is void contract. Third one is unenforceable contract. Fourth one is illegal contract. Valid contract, void contract, voidable contract, unenforceable contract, illegal contract. Valid contract means a contract which is within the meaning of section 2H and section 10 of Indian contract is valid contract. Void contract. So if the conditions are not fulfilled, that contract is invalid. If free consent is not there, capacity is not there, if the legality object is not satisfied, if any conditions is absent, that contract is void contract, it is invalid, it is enforced. That is void contract, is to say. And second one is voidable contract. So when parties enter into contract, they must enter into contract wholeheartedly with free consent only. Suppose if you don't marry me, I commit suicide. So that girl will commit suicide. Invariably, he will marry. That is voidable contract. Voidable contract. And similarly, the grandmother insists son's daughter and daughter's son to get married. If you get married, both of you, then only I give property. Otherwise not. Suppose if you don't marry, I will die, like that. She gives any coercive methods, adopts any coercive method. Invariably they get married. Maybe the grandmother will die, or maybe the reason grandmother will not give property, then that marriage also is coercion. It is not valid. Undue influence. Also manager is there, clerk is there. The manager insists the clerk to marry his daughter. He doesn't like to marry. If he doesn't marry, his promotion may be stopped or he may be removed from service. If I don't agree with the offer of my manager, my life career will be spoiled. For that, married. That is called undue influence. Similarly, coercion is there, undue influence is there, fraud is there, misrepresentation is there, mistake. These are called flaws of the consent. Flaws in consent are obstacles in the consent. So, if anything is influenced, that contract is voidable. Voidable contract is that contract which can be repudiated or avoided at the option of one party. The person who was subjected to flaw in consent alone can avoid the contract. If he keeps quiet and it is valid, if he doesn't keep quiet and he wants to challenge, that it will be voidable. It will be voidable. Suppose voidable. So out of old woman, if as she threatened me to commit suicide, I married her. Otherwise, I am not interested to marry. Subsequently, he can avoid. So if he adjusts, that is valid marriage. If he doesn't adjust, no, I don't like to marry her. She threatened me commit suicide. I can no more stay with her. If it tells, she can repudiate the marriage. That is the marriage also is a contract. That contract is called voidable contract. Please remember, void contract is 100% invalid. Valid contract is 100% valid. Void contract is not 50% valid. Voidable contract is either valid 100% or invalid 100%. If the aggrieved keeps quiet, it is 100% valid. If the aggrieved challenges, and it is 100% invalid. So these are this thing. Next topic for discussion is breach of contract. These are the five. Next is unenforceable contract. When you sell your house, when you sell your two-wheeler or four-wheeler, mere possession is not enough. It must be registered. If it is registered, only the contract is valid. If you give possession of your house or car, nobody will accept. You should have proper documents and register them and transfer in the appropriate office, then only. That is called, if it is not registered as per the technique, if the technical formalities are not fulfilled, that contract is unenforceable contract. Finally, illegal contract. Illegal contract means two parties enter into an activity which is prohibited by law. That is called illegal contract. A and B enter into a legal act, illegal act, or illegal act by illegal means, that contract is illegal contract. It is conspiracy under section 2. It is an offence under section 120A of Indian Penal Code, and the persons are punishable under section 120B of Indian Penal Code 1860. Suppose A and B enter into contract to kill C. That is conspiracy. A and B enter into a contract to stab C. That is illegal contract. A and B enter into a contract to do smuggling bits. This is illegal contract. Depending upon the nature of activity, the punishment will be there. So these are the different kinds of contract. When once a contract is entered into, will be completed or closed one day or other. Yat bhavati tat nasyati. Everything that is created in this universe will be destroyed one day or other. When once a contract is created, after completion of the contract will be concluded. The contract will be concluded. That is called discharge of contract. If the discharge is positive, that is performance. If the discharge is negative, if failed, that is called breach. If 3 years course student or 5 years course, at the time of joining, the contract is created. If he completes successfully the course, leaves the college with degree, that is called successful performance. It is performance. If he fails fifth year, he will be third year and he will be sent out. That is called breach. So contract is completed in positive way, it is performance. In negative way, it is breach. So here performance, regarding the performance, some topics are here. One is joint promisor. Regarding promisor, in performance, joint promisor. When two or more persons jointly enter into contract with some other, these three persons are called joint promisors. They are having liability jointly and independently. For example, A, B, C took loan of 3 lakhs from D. D gave 3 lakhs to A, B, C. The 3 lakhs A, B, C equally they may take, more or less may they take. After the time is over, if A, B, C are not did not pay, D has an option. D has an opportunity to file a case against 3 of them, or 2 of them, or 1 of them. If D chooses 1 and asks money, A alone can pay 3 lakhs. If he chooses A and B, A and B should pay 150 lakhs each. If he chooses A, B and C, 3 of them should pay 1 lakh each. Whether take more or less, subsequently they can recover by filing suit if necessary. But when once A, B, C jointly take money, they are so jointly and severally. If one alone is sued, if one person has to pay 3 lakhs and 2 are showed, each one should pay 1.5 lakh. 3 are showed, one should pay 1 lakh. Subsequently, more or less can be adjusted and reimbursed by the respective parties. Section 42, 43 and 44 Indian Contract Act lay down the provisions relating to this devolution of property. Devolution of property. So here there is one thing. Next one is appropriation of payments or rule in Clayton's case, section 59, 60 and 61. What happens is, suppose debtor is there, creditor is there, debtor takes loan from debtor from time to time. Time to time we are maintaining some account book with some provision shop man, and 5th of the month we take some provision, 10th of the day we take from provision. Either it may be that credit may be taken once monthly or quarterly or half yearly or even annually. When once 10,000, 15,000 like that, after 3 months the 2 lakhs is total amount is there. After that, when it reaches 2 lakhs liability, the debtor will pay some 50,000. When once he repays 50,000, the debtor has an option under section 59 to against what debt that must be cleared. That the debtor is having option. That is first, 59. 69, according to section rule 60, the debtor doesn't give any direction. The creditor can appropriate it and exhaust it and repay it against any debt of his choice. He may distribute it to all the debts, increasing so that by acknowledgement the limitation period will be increasing by 3 years each. Like that. The creditor has absolute discretionary power. Suppose neither debtor takes any initiative nor creditor takes any initiative, debtor gives some payment, this should be done as per chronological order. Earlier debt must be cleared first, subsequent debt must be cleared later. These are the things which I will take up in the next class. Next one is frustration of object. Frustration of object, section 56. Law will not insist anybody to do what is impossible. What is impossible? If a contract is entered into for impossibility, that contract is void. That contract is void. Suppose a doctor and the doctor, you save my father, I am ready to give 1 lakh or 10 lakhs or I will give you my whole property. And that patient will not be able to survive. He will survive for 1 or 2 days only. But patient's son and doctor enters into contract that doctor will give life. No. If A and B enters into contract that A will give life to dead person. So impossibility of contracts are not valid. Under section 56, that impossibility is known at the beginning sometimes. Impossibility takes place subsequently. Suppose a painter agreed to make a painting of one's father on some first anniversary Shraddha ceremony. Then he prepared to make that painting. Meanwhile, he got a fever or illness or met with accident. He won't be able to do. That the person who ordered for painting cannot file a case. Similarly, the order building apartments are there. The builder promises to give possession of the flat within 1 year or 2 years. Meanwhile, Corona pandemic, COVID pandemic came. Workers did not come. He would not be able to complete the construction and hand over the flats. Then if the purchasers bring an action against the builder, that is not maintainable because of impossibility out of the circumstance as a consequence of COVID pandemic. So then the builder will have a relief to get exemption from the liability. That is frustration. Next topic for discussion is novation, section 62. So any contract is valid for 3 years only. When 3 years period is over, without completion of 3 years, it must be completed. For example, promissory note. A gave loan of 1 lakh to B for 1 lakh. It must be cleared within 3 years. Before 3rd year, B approaches A. I have no money. Please cancel old contract and write new contract. Cancellation of old contract becomes consideration to new contract. Again, 3 years time will be there. In first instance, terms of contract same, parties are same. That is first category under section 62. Second category, before due date, B approaches A. So I have to pay you 1 lakh. I have no money, but C has to pay me 1 lakh because you cancel the old promissory note between A and B and create new promissory note between A and C. He has to pay me 1 lakh, he will give you that 1 lakh. He transfers that liability. Then here terms of the contract, promissory note is same, parties are changed. Third thing. Suppose instead of re-promissory note, A may give you some gold or he may ask C to give some gold. A contract is entered into. Terms of contract changed from promissory note to mortgage or pledge, and the parties also have been changed. So these three categories. This is what is called innovation under section 62 of the Indian Contract Act. These are the various breach of contract. Next one is remedies. Suppose when a contract is entered into, one party commits breach, the other party approaches the court, there are so many remedies. Number one, specific performance or specific restitution of property. That is one category. Suppose specific performance means you have to, so A wants to purchase the house, B wants to sell the house. A doesn't sell because rates increased. Purchaser can file a case for specific performance means taking the remaining balance of money, A has to sell. That is called specific performance. Suppose A placed order for B and B brought the goods, but when the rates increased, B sold the goods to some other party without giving them, then big rates are increased. So if B brings an action against A, then B has to bring the supply the goods for same price only. That is specific restitution of property. Similarly, compensation. Different kinds of compensation are there. Normal damages are there. Compensation means if one party commits breach, other party can bring an action for compensation or damages, nominal damages, exemplary damages, quantum of damages, Hadley versus Baxendale, different types of there. I will take up in that particular chapter. This is with reference to various. Then injunction is there. Lower court level we call it as injunction. Higher court, High Court, Supreme Court level it is called writs. Injunction means is an order of the court, directing a person or authority to do an act or not to do an act. Suppose due to some violation of municipal rules, a building is constructed, municipal authorities wanted to demolish that house and the party will approach the court to stop it. Then the court may stop. We are hearing the case until and unless ultimate judgment has come. Don't demolish that. The court will give an injunction. Similarly, in fields, supply of water, not to supply water, so many things. So injunction is an order of the court commanding an individual or authority to do an act or not to do an act. It may be positive injunction or negative injunction. These are the different kinds of remedies available. These remedies chapter I will take up it. And the last chapter for discussion is quasi contract. Generally, contract is entered into out of an agreement between the parties. There are circumstances under which a contract is entered into out of principles of natural justice. The type of no one shall enrich any benefit at the expense of other. We must not get the benefit of anybody. We should not make other unhappy for our happiness. That is the principle of the Dharma Sutra, principles of equity. Section 68 to 72 of the Indian Contract Act speak about 5 kinds of quasi contract. Those 5 kinds of contracts mean section 68, the necessities applied to minor. Because contract with minor is void, but if anything is given to minor can avoid the liability. But if anything is given, some 50,000 worth of money is given to minor, for necessities, food, clothing, shelter, medical aid, minor cannot avoid the liability, saying that contract with minor is void. That is one thing. Second, 69, obligation for reimbursement. Suppose I am residing in a house, but my house, I am paying rent of 10,000. My house owner did not pay house tax. House tax people came and wanted to close by, seal my house. So I cannot be pushed into street. I pay that house tax of 50,000 and subsequently I can ask the house owner to reimburse in give it 50,000 or adjust it in future rent. That house owner said, no, who asked you to pay that? I know the municipal people, I can manage it otherwise, is what he cannot say. If the owner says, he can file a case against him to recover that. That is one thing. Third, the last one is non-gratuitous act. Non-gratuitous act. Because suppose a courier man gives some material to house B, thinking instead of house C, thinking that it is house C. Suppose wrong delivery is given. One Telugu movie, cake is given to one party instead of other party. They have consumed the cake. The courier man comes again, and they cannot say no. They should pay the money. If any wrong delivery is given, wrong payment is made, we have to give it back. That is called responsibility in respect of non-gratuitous act. Next, that is section 70. 71 is the finder of lost good. When you are going on the road, you find some handbag containing money, you have to look for the real owner and give that money. That is called 71 long kind of liability of a person, liability of person to return the money. That is section 72. Suppose A and B took loan of 1 lakh from C. A cleared the loan of 1 lakh. Subsequently, B also thinking that A did not pay, he should pay. That is, he received when he should not receive double payment. He should say that no, your friend has already given me like that. Suppose when some articles are supplied, 50 persons are there. 40, have I given you? He will say, yes, I received, he should say. So without telling, he takes the second time, that is not fraud. It is breach of quasi contractual obligation. In our regular course of life, some things, certain things are supplied to everybody. Having received once, if it takes second time, it is breach of quasi contractual obligation. These are the various issues relating to this. So in this particular lecture of 1 hour 6 minutes, I have completed the whole syllabus, meaning definition, elements of contract, each and every element, different kinds of contract, and different kinds of contract, each and every item in subsequent chapter, breach of contract, performance and breach, and subsequently remedies, and subsequently quasi contract. These are the various issues I have completed. This is the summary. In the next chapter, I will take up contract meaning definition 1 and offer acceptance, like that I will complete. Thank you very much for your patient hearing, dear.